Hi, my name is William and I'm a trainee solicitor at a city law firm. Today we're going to be discussing some frequently asked questions relating to family law, and we'll be looking at subjects such as divorce and relationship breakdown, cohabitation, finances, children and Solata.
Hi, my name is Janette Johnston and I'm a family solicitor here at a city law firm, and I'm here to explain as best as what I can in relation to these subjects.
We're going to begin by looking at relationship breakdown and divorce. So Janette, if you could briefly begin by explaining what the court process is when obtaining a divorce and what grounds under which you can bring your divorce petition.
Okay, so the process of making an application to the court is quite straightforward. You can either do it online or you can instruct a solicitor. There are several grounds for divorce. There's adultery, there's unreasonable behaviour, there's desertion, and the separation for 2 years and 5 years. There is another ground of unreasonable behaviour, but those can be quite contentious. The government has just passed some legislation in relation to no-fault divorce, but that is yet to be processed through the court forms. The process is relatively straightforward. It's the completion of forms, basically, which are filed at the family court. Following that, we would apply for the decree nisi, and followed by that would be the decree absolute.
And is it a requirement that I go to court if I am seeking a divorce?
Not always, and in most cases not. Usually it's a paper process, but on some occasions where the divorce is contested, the judge sometimes will request that the parties attend for directions.
Okay, thank you. And how long would you say it usually takes for a divorce to be processed by the court?
For a straightforward matter where the parties are in agreement and there's no contentious matters, it usually would take between 6 and 8 months.
Great, thank you. So we're now going to briefly look at cohabitation. Janette, if you could just begin by explaining what cohabitation is.
Cohabitation is when two parties live together. They're not married, and they may or may not have purchased some assets together. The law that governs it is quite different. It's under the Trustee of Land and Trustees Act 1996. And within that act, it gives parties who cohabit certain rights. The law has not been updated in this area for a good 10 years, and it can be quite complex. So if you need advice on this, it really is specialist advice, because all circumstances are different, especially if you have children, because when children are involved and you're not married, you are always advised to consider an application under Schedule 1 of the Children Act.
And what are some frequently encountered issues that cohabiting couples might face when they're cohabiting and they separate?
Usually the problem faced is that they do not have what's called a cohabitation agreement. So they haven't agreed at the outset what the agreement will be if they depart. So the court has to scramble round and find out what agreement, if any, they entered into. For example, someone may have contributed a lump sum of money. Someone could have made home improvements. All these things, you have to search around for receipts and things like that. In other cases, it could be quite straightforward, where they have documented at the land registry what their share is of the property under a deed of declaration. But sometimes it can be quite tricky, simply because people don't think of this process before they enter into buying assets.
So you'd recommend that couples that are unmarried do document and have a cohabitation agreement in place where possible?
Absolutely, and to always consider a deed of declaration because that can be filed at the land registry, and it simply records each party's interest in the property when it was purchased.
Okay, perfect. Now we're now going to move on to look at relationship finance. So we understand that dealing with financial aspects upon separation or divorce can be highly emotive and difficult to resolve. So why can resolving financial disputes be so complex? And what examples can you give that add to the complexity?
Well, finances can be complex, especially if there's a family-run business, if there are trust funds involved, if the parties just don't agree. There could be assets that one of the parties has owned before the marriage, and all of that needs to be delved into quite deeply in order to come to a reasonable settlement. And of course, children is a priority under Section 25 of the Matrimonial Causes Act. And if there are any young children, any settlement must take those children into consideration. It's not straightforward. What the court tries to do is try to give the parties an agreement that they both can live with.
And when parties are resolving matters of finance, how do they usually document their financial position to the court, and what is a Form E?
Okay. Well, the financial position, if you can't reach agreement, it's a three-stage process. The first process is that you would make an application, and the court would give directions when you would file a financial statement. It's quite a long document, and you need a lot of disclosures supporting what it is, what assets and what liabilities you have in your family, basically. That is exchanged with the other party, and the court will set the matter down for a first appointment. The court at that stage will just simply make sure that the parties are in agreement, that they're happy with the disclosure that they both have received and the questionnaires have been answered properly. If there are any outstanding issues, it's unlikely that the matter will be settled, and the court will then set it down for what's called a financial dispute resolution. The financial dispute resolution is a good hearing because it's the only time the judge will have the authority to look at without prejudice correspondence of the parties as to really what they want. And the court can give an indication as to what is reasonable in these circumstances. So it's a good hearing to go to because both parties will know that a judge will have looked at the papers and come up with a reasonable settlement. If the parties don't have to agree what the judge suggests, and they can ask that the matter be set down for a final hearing. And that's what happens. If you cannot agree, it gets set down for a final hearing, and the costs of that are extensive.
And what might happen in the event that one party refuses to disclose all of their assets to the other party?
Well, the court has power to make an application that they do disclose them. The court has various powers. So if they don't disclose them, they will get adverse cost orders against them in that respect, unless they can prove that the asset, has gone, basically. There's lots of case law, what happens to people if they don't disclose what they should disclose.
Okay, and we're now going to briefly discuss the implications of having children when getting a divorce, as this is often one of the most pressing issues faced by both parties. So what rights do parties have to see their children following a divorce?
Well, both parties, provided they've got parental responsibility, have equal rights. And children are so central to any marriage. It's important that both parties really work together to make sure that both parents have a good relationship where the children are concerned. And that means entering into agreements of when the absent party can see the children of the family. Also, I would even go further to see grandparents and all those relations that families are, need basically. So it's very important that, children do see the absent parent, and a formal, not so much a formal agreement, but as an agreement as best you can be reached. If a party refuses contact with the child, they'll have to give the court a pretty good reason for not allowing that. And the only reason they can give, which the court would accept, would be a safeguarding issue. So it's pretty harsh. You can't say you can't see the absent parent because I don't want you to see daddy today or mummy today. That wouldn't be a good reason.
And in the event that the parties can't agree who the children should live with, the court would then step in and set out contact arrangements for the party that, is not the primary carer for the child.
Yes, absolutely. So an application would have to be made to the court. The parties would be advised to attend mediation first to see what they could agree. When an application is made to the court, safeguarding checks are made by the court, and usually the magistrates will deal with that. I often say to clients that, the best agreements are the ones that they make between themselves rather than magistrates, as they will not be happy with what the magistrates come up with.
Okay, so the emphasis is definitely on parties resolving the issues between themselves. We're now going to briefly look at child maintenance. So Janette, what is child maintenance and when might it be paid?
Child maintenance is money that the caring parent who looks after the child receives from the absent parent, basically. And the child maintenance service lays down what that is through statute, basically. So, for example, for one child, you get 15% of the absent parent's gross income, excluding pensions. For the child, if you have more than one child, there's an increment that goes on that, and so forth. So it's a sum of money based on someone's salary to give the carer income to help towards mortgage, to help towards anything to house their child. It doesn't directly go to the child itself, but it would go to the other spouse.
Okay. Now we're going to turn to Solata. Janette, if you could begin by briefly explaining what Solata is and why a Solata claim might be made.
Solata, as I explained earlier, is the Trustee of Land and Trustees Act 96, and it is the powers under it allows an order for sale of a property where one trustee does not agree. Solata is used in many circumstances, but it's usually when two parties, or maybe more, have entered into a trust in relation to an asset. So therefore, if you are living in a property, you haven't, it's not a joint mortgage or a joint asset, which is registered at the land registry, you may say, right, I did give you a lump sum, but that's not recorded somewhere. Solata sort of deals with that sort of thing under a resulting trust. You may have a constructive trust as well, where you say, oh, I've relied on this person forever, and it's not fair that I've been looking after them, and our relationship is broken down, and I get nothing. And then you have to scramble around looking for all the evidence and support of that. So the Solata is a very complex act, and as I have mentioned earlier, it hasn't been updated for quite some time. It's a big movement through resolution, who people are trying to encourage the government to update it. And certainly when I attended the resolution conference at the Law Society, there was a big movement, or should I say a show of hands, to say that it should be updated, because it's really unfair that people who cohabit do not have the same rights as people who are married.
And what steps would you recommend parties take to avoid a Solata dispute in the future?
Well, again, it goes back to making a cohabitation agreement or a living arrangements order, or document in writing what you want at the outset. In circumstances where people meet and they decide to live together, things can be quite different when the relationship breaks down, especially where there are children. It can be very tricky, and it needs to be made quite clear in any relationship what finances, what the parties are going to do with the finances. And here we would certainly give advice, if there was children, if possible, to make a Schedule 1 application, so the children's needs are provided for under Solata. It's usually a joint application, a Solata application and a Schedule 1 application together.